I'm Dr. Yuvaneshwari, working as an assistant professor and PG Research Department of Commerce CA at Comedino Arts and Science College, Satyamangalam. Today we are going to discuss a topic on company law. So what is the learning objectives we have here? So understanding the meaning and kinds, it gives an allotment of shares, understanding the meaning of debentures and their kinds, it understands the shareholders equality, debt, equity, obligations and ownerships. So formations of a companies, how the company should be formed. A companies come in existence, a group of people come together with a forming an association to exploit the business opportunities. It brings together main material, money and management. So how the companies should be formed through promotions and incorporations. So incorporations through availability of proposed name of the companies, applications for license should be provided. SEBI, you have to get an approvals from the SEBIs to the draft prospectus. Preparations of the memorandum of associations, preparations of articles of associations, the preparations of the prospectus should be good. Succession of the underwriters, brokers, solders and auditors, etc. have to be good. These are the procedures to form and formation of a company. So shares, what is meaning of a shares? The capital of a company is divided into a number of its called as shares. The types we have an equity shares and preference shares. In preferences we have an cumulative and non-cumulative preferences, participating and non-participating, convertible and non-convertible preferences. We have an redeemable and non-redeemable preferences. So share capitals. So what is mean share capitals? Some sort of nominal values of shares of a companies. So types we have preferences share capitals, the sum total of the nominal value of preference shares of a companies. Equity share capital, the sum total of nominal value of an equity shares of a companies. So classifications of share capitals, we have an authorized share capitals, issued share capitals and we have an surprised share capitals. So issue of shares, we have an issue of shares to the vendors. A companies may purchase a running business and pay to the vendors purchasing considerations in the form of a shares. Issue of shares to the promoters. A companies may allot fully paid shares to the promoters or any persons for providing technical information for engineering services, plans, outlay, etc. Issue of shares for cash through applications and allotment. So next, articles of associations. What is articles of associations? So internal affairs to be taken places, the benefits given to the shareholders, they place a part subsidies to the memorandum of associations. So what are the contents we have in articles of associations? The exist of table A is applicable. Different classes of shares should be and rights should be added. Procedures of issuing share certificates and share guarantees. The alterations of share capitals. Borrowing powers of directors. Voting rights of members. Then alterations of articles, we have a right to alter and alter expressly conferred by section 31. Statutory powers and cannot be navigated in any way, done by passing and special resolutions. The copy must be filed with the register within 30 days of passing the said resolutions. Binding force of memorandum on articles, the company should be bound to its members. Each member should be bound to the company. Each member is bound to other members in especially case only. Neither the companies or nor the members are to be bound outsiders. So doctrines of a constructive notice, a person expected to inspect the public power documents, he should have knowledge which is action is not authorized to the directors. Even if not inspected these documents, he should be assumed to have to be done. Doctrine of indoor management, exemption to constructive notice, offer protection to outsider dealing with the companies. It gives an outsider confidences. Doctrine has to be applied making companies liable in case they whose were appointed for defective, who were appointed properly but were not to be elected necessary authority. Exemptions to the doctrine of indoor management. What are the exemptions we have in doctrine of indoor management? Knowledge of irregularity, sufficient ground of suspension, forgery, act outside apparently authority. The next, what are the differences we have in memorandum of association and articles of associations? So in memorandum of associations defines the limits of some objects of a company. In articles of association, internal regulations to company subsidiaries of a memorandum. The subordinate should be act only, subordinates to be act to the memorandum. It should be filled with register by a companies. The public limited companies need not be separate, need not be filed and separate of articles. It gives a relationship between the companies and outsiders. It gives a relationship between the companies and members. Thank you.